Uh, Actually, I was asked to comment on the paper Kavita sent to me. So, and respected chairperson and the August gathering, thank you very much for giving me this opportunity to comment on a paper on a subject on which I have been working for many years now. And thanks also to the Kavita and her group for their interest to study the northeastern region of India, which is considered the most neglected part of the Indian Union. So I love to read out my comments. So, and if anybody is interested, I can send it to you through emails and all. This paper presents a very good response to the topic on land management and local self-governance in Meghalaya. Each section is relevant to the said task and makes a valuable contribution to the body of literature on the 6th schedule and its implications for land management. Among the positive points, the first one is the author has made a very good attempt to give the historical background of the 6th schedule. She has also analyzed the difference between the original draft presented to the Constituent Assembly and its watered down version that was approved. If used for analyzing the issue at hand, it can help one understand many problems that arise in the controversy around the new Shillong Township. Also, the clash between the Khasi traditional and modern management system is well presented. Equally well presented are the political issues around the 6th schedule and its application to Meghalaya. The author explains clearly the difference of view between the state legislature and the autonomous district council and its political implications. The author also explained well the political implications and the original suggestion in the draft presented to the Constituent Assembly to have an intermediate level a body of village council and chiefs, and the contradiction of creating an ADC to protect the traditional systems and of excluding the traditional leaders. Also, the shortcomings of the 6th schedule are well analyzed, particularly the implications of the absence of a role for the village council and the CMs, and the tension that it symbolizes as well as creates between the traditional system and the modern state. Among the issues analyzed under the issue of clash of systems are the intra-community conflicts, conflicting interpretation of the right and Chianti lands, and of the customary practices vis-a-vis the modern law. In this context, the role of right lands in Khasi identity formation is well analyzed. The author has rightly mentioned that the present role of governor is creating problem in the ADC administration in the formulation of laws and regulations. This is true in case of other northeastern states too, where the governors constitute what Sanjeev Barua calls a parallel political system, wherein they have extraordinary powers which is not the same in other parts of the country. The author has very well explained the issues of privatization of community land by the tribal elite and the need for a cadastral survey for all land. While these are the positive points about the paper I found, I'll just read out what shortcomings I have found in this paper, I think, which are more important in these discussions. What I found is that the shortcomings arise mainly because these positive areas are viewed in isolation and their link with one another and the historical processes are not well analyzed. The first one is there are some important factual errors. The author begins by saying that in page 1, the tribes of the northeast were accorded a special status. That is not true. Only the tribes of the present-day Meghalaya, Mizoram and parts of Nagaland were accorded that status. The tribes of Arunachal Pradesh are hill tribes, and that state doesn't come under either the 5th or the 6th schedule, nor do the tribes of Manipur, Hutu are hill tribes. Tripura too was excluded and the tribal district came under the 6th schedule only in the 1980s. The Karbi and the Dimashas of Assam got it much later and the Boro of Assam only a decade ago. I think you need to explain that the Northeast is not under, yeah.
It's not a homogeneous group.
Yes. And second one, also the statement that the 6th schedule was an attempt to find a compromise between the national identity of mainland India versus the Far East hill tribes is only partially true. Two other components are ignored in it. The first is that the sixth schedule did not come out of a vacuum, but it is very much a continuation of the special provisions made in the Government of India Act 1935. Equally important is the mainland lack of understanding of the aspirations of the Northeast tribe that wanted autonomy. That's the historical aspects of the sixth schedule. But the overall thinking of the mainland and even most non-tribal leaders of then Assam and the constituent assembly members of Assam was assimilation based. It was not integration based. They knew the India of the Aryans and the Dravidians, not of the Mongoloids. I can give you the references for all this. So even though the sixth schedule was granted to some tribes of the Northeast, the colonial notion of primitive tribes reside in the hills was continued to exist. This is made even more apparent in the structure of political participation and resources available to the Autonomous District Council under the sixth schedule. You have mentioned about it to some extent. As a result, the autonomous councils have become smaller areas of contest for mainstream political parties. So, another important point which is missing, I think, is the contradiction between the traditional and the modern state and the legal systems are mentioned, but their role in the conflict is ignored. The right country land issue is present as intra-tribal conflict. In reality, it is a result of the interface between the formal and the traditional systems, of the encounter between them. It is a result of what the author calls commodification of land. The intra-community clashes are initiated by this interface. The modern system is imposed on the tradition without any effort to integrate the two. For example, I can give you the example of the classification of land. The nation-state statistical classification, there are huge difference between the nation-state statistical classifications of land and the tribal classification. And no attempt has been made to integrate these two. As a result of this, tribal people in that region, they do not understand the nation-state's classification, and the state doesn't understand the traditional classification. So I think that I see as a problem what is happening. And let me speak about the Supreme Court judgment. That is also that too is a result of the commodification of forest and the use made of the traditional system by the commercial forces for its use as commodity.
I would just like to add that the case of Supreme Court judgment was that I've mentioned that the Supreme Court was forced to bring in a moratorium on all timber trade from Meghalaya because we are also covering the environmental part of it. So the land belongs to the people, the forest belongs to the people, so I can cut down as much trees as I want. And this was like it had led to severe critical levels of forest depletion, and the Supreme Court in 1997 had to step in and put a moratorium on all sorts of timber trade in the region. So that's what her comment is about.
Because of the high unemployment and absence of other sustenance, smuggling of timber had become a major source of income for the people. In that case, the Supreme Court judgment was really important. But you know what happened? That though the judgment was important, but not the approach. Because it was a highly nature-oriented environmental approach, ignoring the poverty level of the people. So after what happened? The ban on logging without providing an alternative caused serious problems, and in many cases the result was the opposite of what was intended. What happened once the Supreme Court gave the judgment? The people thought that, okay, we would not have any rights over the forest land, so let's cut the trees. And within 1 week or so, people started cutting trees, and almost everybody does it, because we had interviews with many village leaders. So what were their opinions? They said like, it was banned without giving us any other alternatives of livelihood. So we started cutting trees. So those implications actually we need to look into, I think, later on. Also, the NGT ban on mining is a result of the same interface. Besides, a huge chunk of forest land is either given on lease or sold by the state to companies for mining purposes. When you look at the issue of forest conservation, then you have to look at all the factors. You know, it's not only the community is destroying the forest, but also about what government interventions, what are the government interventions which are taking place or going on in that place. According to the study we did, the mining alone in Meghalaya from 1947 to 2000, it was a database study. The amount of land was they used for only the mining purpose was 19,000 acres of land. Once displaced by development project without rehabilitation, the tribes of most of India, this is not only in case of Meghalaya but in other parts of the country, began from a constructive to a destructive dependence on forest. So I can give you references of all our studies. Thus, one area the author needs to explore more is the legal ambiguity of the interface. You have mentioned about it, but I think you need to explore more on it. The legal ambiguity of the interface of these two systems, the traditional and the modern, which remain parallel and are not integrated. For example, the 6th schedule allows community ownership in Meghalaya. You have talked about it, that community, they are the owner of the community land. But at the same time, you have to speak about the Land Acquisition Act, which, according to which it gives the state the power of eminent domain. The state is the owner of community land, or state can acquire land at for any project or any public purpose, and state will is the only authority who can define a public purpose. So the author has mentioned the creamy layer, but has not specified that their role in using the formal law to interpret the traditional law. To suit their needs is basic to the conflicts. I believe that what you have quoted S.K. Blah, you have an interview with him, but I believe that S.K. Blah has expressed this contradiction beautifully, and that should be the starting point for the critique of the 6th schedule. There is need to explore more on other causes of land alienation among the Khasis, such as you have mentioned about it, but you can explore more on it. I think that will really would have added authority to the argument. The author says that many conflicts are because of community ownership, or she says the result of absence of records of rights and protective legal mechanism of compensation and rehabilitation are because of community ownership. To say in a simple sentence that compensation and rehabilitation is poor. The author needs to go beyond this point. The rehabilitation is poor not because that they have community ownership. Rehabilitation is poor because the state doesn't have any rehabilitation policy or law. The nation, the India has a rehabilitation policy, and the Land Acquisition Act, which till 2013, till the new law came, the community the people who depend on community land, they are not recognized even as displaced people. So that is why the rehabilitation is poor, because in Meghalaya most of the people, they depend on community land. I mean, it's not only because they do not have that land documents, it's because that law doesn't, the existing law, the community ownership is not recognized. I can give you some examples of some case studies in Assam, among the hill tribes. One lady called Rohila Rangpi, she came to know about her displacement at the time of displacement, because she lives in the community land and she was busy all the time with her sick husband. She doesn't have any interaction with other community people for a long time. So she came to know about displacement only at the time of, because you are displaced because you don't have any land documents, so you are not qualified to be a displaced person. So these are the other issues I think you need to explore on, because if the Land Acquisition Act had systematically recognized community ownership of each clan and provided rehabilitation facilities rather than one-time cash compensation, this problem would not have arisen, at least at the intensity at which it arises at present. That is my feeling. In case of New Shillong Township project, it is said that the people did not participate in the survey because Durbar leaders did not give their consent, and that no step was taken by the local administrator. This is partially true, because till the new law was enacted in 2013, it was not mandatory for the administration to get people's consent under the Land Acquisition Act, because it may true partially because Durbar headmen, they had leaders, they didn't give permission to people. But usually this is the common, this is what is happening in all the projects. It's Land Acquisition Act. According to it, people consent is not important till 2013 when the new law came.
I'm not mentioning about consent, but I'm talking more about cooperation, in the sense like consent would, in land acquisition, what is the consent really? I mean, if it has to be acquired, it has to be acquired.
Yeah.
So, but of course we can talk about it later, because I think I would also like to hear comments from other people.
And the last one is not the last one, but you have mentioned about the Right to Forest Act, and you have mentioned about the implications of the Right to Forest Act, because of the privatization going on in the, but Right to Forest Act has two dimensions. One is the community has the right over forest land, and the second one is community has the responsibility for forest conservation. I can give you references of some good examples of what is happening in Assam, because once the Right to Forest Act 2006, according to that, in some villages, in some tribal villages in Assam, since people are given the responsibility for forest conservation, actually they are doing very good in that, because traditionally they know how to conserve the forest. So, and finally, not once has the author mentioned that the Khasis are, you mentioned it in your presentation, Khasis are a matrilineal tribe. That mention would have helped her to see the implications of the contradictions for the gender issue. So, I think this is what I wanted to